regarding Stephen Castanedo, we're in a little more urgent situation. Not to downplay Joshua's situation. Now, as I said previously, there are some similarities in the cases, and one of them is they really never had a chance ever since they were a kid. Stephen's father died when he was 3 years old. He had a really less than stable childhood. He was born in Staten Island, New York, but they ended up moving to he moved into his maternal grandparents' house down in Port Charlotte, Florida. And again, we have another case here where tragically, his father passed away, but what happened to his mother? His mother became addicted to drugs, specifically crack cocaine. So now you have a kid who's dealing with the trauma of losing a father at the age of 3. I'm not a psychologist, but God knows what kind of effect that has on a young kid growing up.
Yeah, especially boys, because usually it's the dad that helps the boy become a man. So to not have that male figure in your life as a boy is very tough. I know that for a fact. I have my dad, but I know how tough it would have been if I didn't have him.
Well, likewise, Manny. I have both parents too. So, but the mother didn't handle things the right way, and she became addicted, like I said, to crack cocaine. So, again, we have a situation here where you have a kid growing up throughout his pubescent years, basically in a dope house. I mean, it's just that simple. And so come the age of 15, 16, 17, what's all this kid gonna know? And it's like he's gonna know drugs in the drug world, how to what drugs to do, how much drugs cost, how to cook them up, if you will, and how to steal, and that's what you learn when you grow up in a dope house. So now, look, this cannot be used as a mitigating factor legally in the state of Florida. You can't say, well, you can use it to persuade, to kind of like curry favor with the court. If a judge has a heart, which few do these days. But being high or being around drugs in and of itself is not a legally justifiable mitigating factor. But plenty of others. Stephen, now, again, he is 17 years old at the time of this incident. Okay, this is back in February of 2008. And he was selling drugs. And he had, a couple buddies, Matthew and Juan Tavares. And, look, I in no way am I trying to minimize the loss of a life here, because that's eventually what happened. Juan Tavares lost his life in this incident, and my heart goes out to the Tavares family. And in no way am I trying to minimize that loss. But Juan Tavares was shot. It was a drug dealing house, and Juan Tavares was shot. Now the state of Florida is going to tell you Stephen Castanedo shot him. But the forensics on that are feckless at best. And they're basically going, at the time of trial, they were basically going off the account of 3 eyewitnesses. The other drug dealer, Matthew, he was questioned too. But the police rolled on him, so to speak, to get him to rat out Stephen. And so for all we know, Matthew shot the gun. All I can say with certitude is that to this day, Stephen's now 24 years old. Stephen denies this shooting adamantly. Nevertheless, not to minimize, it was a drug dealing house. These types of things happen in these toxic environments. Now, who shot him? Nobody really knows for sure. I don't even think the state of Florida knows, Vinny. I do know that he was interrogated by Detective John McHenry, and Stephen refused to talk until his grandparents were present, and McHenry gave him the runaround. Typical interrogator, saying, that his mother had given verbal permission by telephone, but, that they would only ask him a couple questions and release him. Well, that's a lie. When you're temporarily detained like that, really that means you're under arrest. Okay.
Exactly. Anytime, if a cop puts you in handcuffs and takes you to a station, that's arresting. It's whether or not you spend more time in jail is different. Like, that's what most people understand, is that you can be arrested but then let go. But the point is, you've still been arrested. You don't necessarily have to be handcuffed and in jail for it to be an arrest. I think some people forget that sometimes.
This goes back to what you said, in the beginning of this conversation, Vinny. For those of you, if anything ever happens, whether you're pulled over for anything, just so you don't answer questions. As a matter of fact, Google that on YouTube. I don't answer questions, and you'll get a guy named Suter, and he'll show you examples of how to handle these officers. Don't answer questions. If anything happens to you, just don't say anything. Yeah. At least not until you have defense counsel.
Absolutely. That's what my mother used to tell me all the time. She said, if you ever get arrested, first of all, she said, use the one phone call to call home. That was number one. But number two, she said, every question you ask, your answer is, I want a lawyer. That's the only answer you give them every time. I want a lawyer, no matter what they say, until either a lawyer shows up or until your parents show up, or both. That was the number one lesson my mother taught me as a teenager, because I was the age I was at where, God forbid, something like that could have happened to me.
Well, your mom's words were prescient, because she's precisely correct. Mm-hmm. But the problem with the Castanedo case really involves his defense counsel at the time, a guy by the name of Kevin Shirley. Okay, the prosecutor was a guy named Thomas Krug, Krug, who is now a sitting judge. But he was then a prosecutor, and he's the one who prosecuted Castanedo. And here's where the problem lies, the way I see it. Kevin Shirley had other cases he was defending, other murder cases. That they charged Stephen with second-degree murder. Kevin Shirley went in front of the court and said, "Look, Your Honor, I have not had the time to depose witnesses or present a mitigation." Now, present a mitigation means present legally justifiable mitigating factors that could lead to a downward sentencing departure, or even more than that. So the judge flat out denied it. He said no continuance. Sentencing will proceed soon. So what this did is this effectively gave the prosecutor all the bargaining chips in the world. Thomas Krug thought to himself, okay, well, if defense attorney isn't ready for trial, and the judge says we're going to trial, or else, look, he was facing a life sentence at the age. Remember, you got to remember, this is all at the age of 17. So Thomas Krug, the prosecutor, has all the bargaining chips. He knows he's got an unprepared defense attorney. So if they go to trial, he's screwed. He's getting life, okay? Because the defense attorney himself is going to be our star witness in our appeal, but that's another story. But he said he was unprepared. He told the court, "I'm not prepared." And So Thomas Krug said, okay, well, I got this guy, you know, pardon my French, but I got this guy by the ass, so I'm gonna throw the book at him. And that's precisely what he did. 17 years old, for a drug-related shooting, you know, and I'm from Detroit, man. These happen every day. You know, they're just pleaded out to, you know, 10, 12 years, whatever. 17 years old, okay, just, you know, sophomore, junior, whatever it is in high school. 35 years, 25 years of that, which is mandatory minimum. So in other words, he's got to serve 25 flat, and then for the remaining 10 years of the sentence, he'll get gain time down in Florida, which is 85%. So at the age of 17 for this incident, he's not getting out of prison if anything happens until he's 53. Now you got to remember, this kid grew up in a dope house. This is a dope house related shooting, and there's really no proof that he did it. So you're just going to throw a guy in prison from the ages of 17 to 53, 35 years, because you have an unprepared defense counsel.
Now, was this guy a public defender? I'm assuming.
Was Kevin Shirley a public defender?
Yeah, the one that you're saying was unprepared. Was he a public defender appointed by the court, or was Stephen able to get his own lawyer, like through help or something? Like, that's what I'm trying to figure out.
No, he was paid defense counsel, but you know, it doesn't even matter. You know, he's a private attorney, but it doesn't even matter. The guy was unprepared. He didn't do his job.
Absolutely, I agree with that.
He didn't present a mitigation specialist. He didn't depose 10 to 12 witnesses, 3 of which are the ones who convicted him. Now, one of those 3 witnesses who convicted Stephen Castanedo has since recanted their testimony, and they now say no. Stephen's correct. Stephen did not shoot Juan Tavares, which corroborates Stephen's story. So, and on a side note, eyewitnesses are notoriously unreliable. Yes. And when you're 17 years old, you know, you have gossip, you concoct stories, you know, who in the hell knows what went on. But, so, Thomas Krug went to the courts with this case on basically on the word of two teen, you know, drug witnesses. And that's what gave this guy 35 years in the Florida Department of Corrections. He like Joshua, he had the same mitigation specialist, Dr. Rainier, out of the Minnesota area. But Dr. Rainier really never did present a full mitigation. There are we have up to 5 mitigating factors that could have legally been presented in front of the judge in a Florida court that were not presented, and that's sad because that's not due process.
It's not at all. and this goes into a similar discussion that I was talking about on a previous show. I think it was Monday, where I said, regardless of whenever somebody goes to trial, you have to have, if you're going to convict somebody or accuse somebody of a crime, you need actual evidence to back up that statement. You can't just rely on word of mouth. That's like a Salem witch hunt. It's ridiculous. You can never just rely on, this person said he did it. Okay, you go to jail. It's like, no. Is there fingerprints on a gun? Is there DNA evidence? That's the thing you need to that's like law school 101. And I didn't even go to law school.
Yeah. That's another thing. Yeah, they found a gun in a lake later, but you're right, they couldn't connect it to him. And they paid Shirley. They paid Shirley $25,000. they paid another guy, his name was Keske, Keske, $150,000 to file 2 motions to withdraw his plea. Withdraw his plea. You know, and again on the gun, you know, they found a gun in the lake somewhere. You know, what would he do? There were probably 100 guns in that lake, but there was no blood. There was no blood, no gun residue on the clothes. You know, you're right. There was no physical evidence. You know, there's no DNA. But what you have here is you have another judge and a prosecutor, Thomas Krug, who is now a judge, who sees an opening. Okay, we have a political opening. We can go and say in our next election that we're tough on crime, and we're going to parade this around and campaign on this. You know, look at we book these teenagers, we hold them responsible, we're tough and all this. But there are some big problems with this here, Vinny, because he didn't get the chance to go to trial because his attorney said he was unprepared. So Krug offered him 35 years. It was either that or face life. Now you're 17 and you're saying, "Whoa, life in prison," and he was scared as hell. You'd imagine.
I can only imagine that you know, a teenager in jail is terrifying. That means, I mean, I've been to the first time I ever went to traffic court, I was shaking in my knees. I couldn't imagine being in a federal court like this.
Well, yeah, and you know, look, again, Stephen to this day adamantly denies shooting Juan Tavares. As a matter of fact, the sober people next door, the neighbors, identified Matthew as the shooter, but officials, you know, they took the word of the drug dealers over the sober neighbors. You know, they saw Stephen as a little family support. His mom was addicted to crack cocaine. You know, we can book this kid, and that's exactly what they did. Look. So here's the deal, Mr. Castanedo. Take these 35 years, or you're going to go to jail for life because your counsel ain't prepared for trial. In my mind, that's a coerced plea bargain. To assume it in a fair court of law, you know, any judge is going to say the same damn thing. That's a coerced plea bargain, which is the number one reason for any post-conviction relief. He had no choice but to take this plea bargain. It was either that or go to trial and face life with a defense lawyer that wasn't prepared. So, and this wasn't even a plea deal. You know, it wasn't like he was pleading down from second-degree murder. He pled from second-degree murder to second-degree murder. Now, how is that a plea bargain?
Exactly. That makes no sense at all. That's not a bargain. That's, you know, I guess the only bargain was no life in jail. That's pretty much it. But you're being charged with the same crime.
And said you're only doing 35 and you're not getting out until you're 53. And so, you know, have fun the next 35 years in the Florida Department of Corrections. Again, 25 years of those are a mandatory minimum with Florida's gun laws. I just want to throw in there that the same mitigator, you know, the same doctor that, you know, that briefly analyzed Joshua, he said that, you know, was Stephen at the age of 17, was he competent to understand the nature of the charges and what's really going on? Stephen said he wasn't, and I believe him. And the doctor, Eddie Rainier, said, you know, he thought there might be cognitive problems, and so they sent for his school records. But during the competency hearing, those records hadn't come in yet. The school was slow, and so they just said, oh well, we just won't consider him then. That's not due process. If you don't receive the record, you say, okay, well, this court's adjourned. We'll continue when we get these records. And we get these school records. Again, you know, with all due respect to the Honorable Judge Charles Roberts, he really should have given time for these school records to come in, to give Stephen the chance to present a full mitigation, which is every defendant's right in the situation, especially a defendant like Stephen Castanedo, who was 17. His mom's a crack addict, and, you know, she's been in and out of the system herself her entire life. So he takes his plea bargain, right? And herein lies the problem, and this is where I could really use your viewers and your support. I mean, our case, this case was, eventually came upon our desk here at the National Center for Due Process. We looked through it, and it just screamed problems, but we had to pick through it with a fine-tooth comb, and we did just that. And we researched up to 5 mitigating factors under that same Florida statute I mentioned to your viewers earlier, 921.0026, paren 2, for a downward sentencing departure. The number one being A, it was a coerced plea bargain. It's just that simple. This was not a plea bargain that he really had a choice at. I mean, he had to take it. It was coerced. If he didn't take it, he was getting life.
Yeah, and it is. It's exactly what it is. It's a lot of pressure, and it's actually something similar to something I remember the last time. Because I remember last time when you were on the show, we were talking about the Dylan Johnson case, and you talked about how when he was getting life, he was offered, like, they were going to coerce him to take they were going to pressure him to take, like, to just serve like 2 or 3 years, and we had the question about should he take the deal, should he not take the deal, like what he should do. And even though this is something more severe, I'm noticing a similarity between the two, like, and I can understand why he would take the 35 years, because when you first top of your head, you're like, okay, I won't spend the rest of my life in here. But when you're 17, you're spending 35 years in jail. That pretty much is your life. Like, you get out at 53.
Yes.
Your life is pretty much, it's 53. Like,
it's a life sentence. You're missing, these prime years of your life, your 20s, your 30s, your 40s, and part of your 50s even, Forget about high school, forget about college. And again, I can't overstate this, Vinny. This kid grew up in a dope house, okay, and he was 17 years old. And so there's up to 5 mitigating factors, and I lay them all out. And I'd like to give your viewers this website. It's nationalcdp.org/helpstephen. All one word. Just type in nationalcdp.org/helpstephen, and that's STEVEN. And they're going to be brought to a page where, my partner and I researched 5 legally justifiable mitigating factors that can lead to, again, an acute downward sentencing departure. Forget this 35 years. And again, is Matthew the one who shot Juan Tavares? Just looking at the information I have, I'd have to say, yeah, I'd suspect him more than Stephen. But look, Stephen had a mother in and out of the system. She was on crack. He had basically little support. So he was a good one to vulture upon. So we have a coerced plea bargain. There's problem number 1. The capacity of the defendant to appreciate the criminal nature of the conduct, that was, his capacity was substantially impaired. That's problem number 2. He required specialized treatment for a mental disorder unrelated to substance use. That's problem number 3. We believe Stephen at least suffered from post-traumatic stress disorder, stemming from his turbulent upbringing. Then you have two more. You have, at the time of the offense, the defendant, again, at the time of the offense, the defendant was too young to appreciate the consequences of the offense. When he was 17, if he did this, and again, Stephen adamantly denies that he did this, but let's say if he did this for sake of this conversation, we feel it can be argued to the court that he was too young to appreciate the fact that he might spend the rest of his life in prison for a dope house gunshot. And lastly is the youthful offender status. All three of these, or I said 5 of these things, and especially the first 3, the coerced plea bargain really bothers me, as an advocate for due process. All 5 of these could have been argued to the court for a downward sentencing departure to get rid of those 35 years. But instead, he took this coerced plea bargain to 35 years. Again, that's, just to make that clear, that's nationalcdp.org/helpstephen, STEVEN, like he is Victor. But here's where I could really use your help, Benny, and I don't know what you and your viewers can do, but if you guys read about this, and we have a lot more information about Stephen Castanedo. That's just one, But I think if your viewers really read into this, I think they'll become enraged. And again, like I said, with the same thing with Joshua, I can read these 5 mitigating factors that can lead to a downward sentencing departure all day long in court. We can cite case law. We can do this. We can hire a fashionable defense attorney, which we're trying to do. And that's great. But eventually, like I said, it's the people. It's the people of Florida and your viewers. It's the people of America who are going to get this kid a fair sentence, not this 35 years garbage. As a matter of fact, Judge Roberts, even said, was your plea made... I'm reading direct testimony from court. Judge Roberts, was your plea made knowingly and voluntarily? Stephen, I had no choice. Judge Roberts, did you ever want to take the plea deal? Stephen, no. 17-year-old Stephen said no. Judge Roberts said, do you feel you were being coerced? Stephen said, I did. And Judge Roberts says, what did you want in this particular case then? Stephen said, a fair trial. Which he wasn't going to get a fair trial. His defense counsel, Kevin Shirley, admittedly was unprepared. Now, subsequent to this plea deal, he got booked for 35. None of those 5 mitigating factors I mentioned were argued, and you can find them all on nationalcdp.org/helpstephen. And none of those were argued. So what we did is we researched these mitigating factors. We found the most renowned defense attorney out of Sarasota, Florida, because we are a 501c3 compliant nonprofit organization. We get a discount, so to speak, on these things. Now, what we're doing right now is we're filing what's called a 3.850 motion, let me rephrase that. Stephen filed a 3.850 motion, which is a motion for proposed conviction release based off ineffective assistance of counsel. I mean, hello? The guy said he was unprepared. How much more ineffective can you be? When your own defense attorney admits it, he's ineffective. So it's just that simple. This isn't rocket science. So, but what we really need you here, Vinny, and what we did is we're outraged at this case. There's no due process in this case. Again. There's not even proof he shot him, but direct appeal was filed tonight. 3.850 motion for post-conviction release based on ineffective assistance of counsel was denied, alarmingly, and that really bothers me. How is a judge going to deny it when the own defense attorney says he was unprepared or ineffective, if you will, basically a synonym? How are you going to deny that motion? So what we're doing is we hired the most renowned defense counsel in Sarasota, Florida. Okay, her name is Andrea, and she is tough. She's a bulldog, and that's what I like about her. As a matter of fact, she's suing the governor of Florida, Rick Scott, right now. But we have all the faith in the world in her. We're also, if needed, we don't know if it's going to be needed, but we think we're going to also have the services of the best mitigation specialist in the area, Brooke Butler. And we're appealing this denial of the 3.850 motion to get the ball rolling again, to get this back into the courts. And now this judge is going to know he has a watchdog watching over him, and that's the National Center for Due Process. No more sneaking under the court system. No more, game over. Okay. Here's the problem, though, Vinny. This work ain't free. There are voluminous amounts of paperwork to go through. And, again, we get a huge discount. We're 501c3 compliant. We have bylaws, Constitution, tied to our Articles of Incorporation. We're closely monitored by the Internal Revenue Service. We agreed to retain the services of this. It's his only chance. He's got one chance, or he's going to be in prison until he's 53. And the only chance is to appeal this denial of the 3.850 motion Stephen filed pro se on his own. And we think we got a great shot at winning. We just don't have the money. She wants, defense counsel is going to want $4,500 for this, and we're we'd like the judge. We don't want to go in front of the same judge. Granted, there are only three right there, and now one of them is the one who prosecuted him, Thomas Krug. But then there's the female judge. We'd like, if we can't get a change in judge, a change in venue, a change in something, we don't want to appear in front of this judge anymore. And we want to appeal the denial of the 3.850 motion, but we need the money. And like I keep saying, it's a common theme throughout this conversation, Benny. It's not a law or a statute or a technicality that's going to get this guy a fair sentence. It's the people. And likewise, we got to come up with $4,500 to save this kid's life. Great chance. We got the best defense counsel in the area. You can see her name on, on nationalcdp.org/help-Stephen. So far we've been able to raise almost $1,100 of that $4,500. And, look, I get it. Not everybody's, filthy rich and a philanthropist. If I could have Warren Buffett's cell phone number or Donald Trump's cell phone, I give Bill Gates a call and say, can we please borrow a couple thousand. But we have to retain counsel. He has to file this in the next 30 days. The initial retainer we can handle, but we're on the hook for the rest. And $4,500, we've collected $1,100 for this. So if you can spread this out to your viewers, Manny, nationalcdp.org/help-Stephen. Whether it's $5, $10, maybe someone's nice and can sympathize with this gentleman. I should say a teenager. Now I'd call him a gentleman, but he was a teenager. Someone can sympathize with the fact that 35 years at the age of 17 just ain't right. And, maybe $50, any amount will help. If we can get 200 people to donate $20, well, we're all set. And it, specifically says any residual funds will go to any future court proceedings. But we're not even thinking about residual funds right now. We're just trying to get to the $4,500.
Absolutely, and like I said, I definitely have all the information here, and I agree with you. Every little bit helps, to help get to that 4,500. And I will definitely, like I said, I have all the information is here. There's multiple sites, nationaldcp.org/help-Stephen. There's nationalcdp.org/Joshua Swartz.
Just national/Joshua.
Oh, it's just Joshua?
Yeah.
Oh, sorry. I had a different link up here. My bad. /Joshua. And absolutely, and definitely help it out. And again, this is the National Center for Due Process.
Yep, we're the National Center for Due Process. We're 501c3 compliant. We're soon going to be 501c4 compliant. We're working with our attorneys on obtaining that, which will give us the right to get involved directly in policy, and politics, basically. But we're not even thinking about that yet. We have a Facebook page. It's just facebook.com/ facebook.com/ let me see what it is. For Stephen, it's right now. My computer wants to be slow. The National Center for Due Process is facebook.com/nationalcdp. Everything, Twitter, National CDP, @National CDP. If you'd like to go to, learn more about us there's all kinds of information posted on our Facebook page, facebook.com/National CDP. You'll see links to our Stephen Castanedo support page. You'll see videos. You'll see all kinds of posts. We're even having a specific raising event. You'll have a 1 in 20 chance of getting a dinner to whatever restaurant you have near you, whether it's a Cracker Barrel, an Applebee's, a Bonefish, or Stephen's actual support page is facebook.com/Stephen Castanedo support.
Okay. Stephen Castanedo support. All right. I will definitely take those links. I will have, like I said, I will have them up on the Boochcast Facebook page later today. I will make sure I direct everybody to those sites, and like I said, like he said, every little bit helps, and we can do what we can, because we're the ones that can help them. We can't rely on the justice system in these particular cases. And
I got one more thing to say, and I got one message
out
there for any prosecutor or judge, but especially prosecutors who are listening. I got a message for law enforcement officials first. There's a better way out there. To the brave young men and women who wear badges, there's a better life out there. Your job is not to serve and protect the prosecutor and the judge. Your job is to serve and protect the people, the other 98%. Okay, so law enforcement officials, we welcome you to join the 98%, to join us, join the National Center for Due Process. But my message to every prosecutor who ever comes across this is that, look, if you follow the law and do your job, then we are on your side and we support you 100%. But if you want to run for public office and you want to cheat, we're going to catch you, we're going to find you, we're going to expose you, and your political career is going to come to an abrupt end.
And absolutely, and I hope they I really hope they get the message loud and clear. And Jason, man, I just want to say thank you so much for taking time out of your busy schedule to talk to us and bring this to our attention. It's always a pleasure to have you on, and I'm going to do everything I can to spread the word about the cause that you're in, because I really believe in it. And hopefully in the future, if God forbid another major thing occurs, I'll be happy to have you back on the show to talk about them as well.
Thank you very much, Benny, and everybody who can help Stephen. We need this. We need to get this money in. So I really appreciate your help, Benny. Best of luck, buddy.
All right, best of luck to you too, bro.
All right.
You're welcome.
Bye.